everyone for joining. My name is Lucy Resar, and I am a program coordinator at Pennsylvanians for Modern Courts. And I want to thank you all on behalf of our organization for joining. And thank you so much to Maria and the Free Library for hosting us. If you have the chance, I'm going to pull up the pre-presentation questionnaire, which is on the screen. And if you scan the QR code and fill out the survey, it really helps our funding. And you'll also be entered into a raffle to win a Starbucks gift card. And for those of you who don't know, I'll provide a quick introduction to PMC. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, fairness, accessibility, and respect. For 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. PMC aims to provide resources to make that possible. And while we won't be providing legal advice today, we hope that this presentation will be an informative and educational experience. And we are very, very honored to be joined today by Maureen Farrell. Maureen is the owner and principal attorney at the law offices of Maureen Farrell. Her firm concentrates on estate planning and probate legal issues. She also represents clients in orphans court in matters where relationships and asset protection are present. Her goal is to make the court and probate process easily navigable and empower her clients in the best way possible. We are extremely grateful to Maureen for being here and sharing her extensive knowledge, and we hope you all enjoy tonight's program.
Thank you so much for having me. Tonight's program is so important because it's an area that sometimes is easily neglected because it's a topic we're going to be talking tonight about estates and wills and topics that have to do with death. And many of my clients, I'm a lawyer and this is my practice area. I concentrate on estate planning and also helping people after death. When they're grieving, it can be a very difficult process when you're grieving to have to get all these papers together and deal with a lot of different issues that can become very cumbersome. So I try to make it as easy as possible. I've been doing this for about 20 years. And I really enjoy the relationships that I have with the people that I've met, my clients and other people. But I see that the register of will slide is up, and feel free to take any notes as you go along. I'm going to be talking a little bit off the slides. So the slides are sort of like just an accompaniment to what I'm saying. And feel free to ask any questions as you go along. Lucy, if you could just let me know if there's a question, that would be great. I'm happy to answer them, and I'm happy to answer them after the presentation. But the first thing I want to talk about is tonight we're going to be using the words estate, okay? And estate sometimes sounds like a big word. Like when you hear the word estate, you think of wealth, and it's like the estate of, let's say, Jacqueline Kennedy or somebody really famous. But an estate is not really a word that means a lot of money or a lot of property and things like that. So most of us actually do have what's called an estate. Okay, so it's a fancy word, and we all have, most of us have some form of estate, and I'll go into that as we go. But the first thing is everybody that's on this who doesn't have a will, okay, or who doesn't have a power of attorney, or doesn't have what's called a living will, which is if you're in a vegetative state and you can't make decisions. Everybody on this call should think about preparing, okay? Because when you don't have these documents, we're going to be talking about the differences tonight when you have a will versus when you don't have a will. And one way or another, if you do not have a will and you die, it's going to create a lot of problems for your family. Okay, so there are many reasons to get a will done. There are many reasons not to get a will done, such as like, I don't have time, the expense, different reasons. But in my profession, in my practice, when you don't have a will, your family is going to end up spending, and you won't know it, okay, because you're not going to be here, but a lot of grief, money, time, and it's So I'm just encouraging everybody on this call to think about getting some kind of estate plan or will. Okay, so when I talk about a will, and you see the register of wills is on this first slide. A will is a document. Okay, it's a contract. I want everybody to understand this. So once you create a will, you're telling everybody what you want after death. Okay, so there are certain provisions in a will that relate to certain assets that you're going to give away in your will. Okay, so a will is going to give away assets such as your personal property. Okay, you're going to give that away under your will. Okay, personal property means furniture, cash, if you have art or coin collections. And interestingly enough, if you have a pet is actually considered, your pet is considered personal property. And many of my clients, I work a lot in Philadelphia and a lot of the different counties, they have a pet. And sometimes if a client dies and unexpectedly, you want to have provisions about what's going to happen. Okay, you put this in your will, the care of your pet. Okay, so that's just one thing like your will can accomplish. That, oh, my pet goes to daycare every day. You'd put something like that in your will, and that you want this amount of money to go to that. And it's really important to do that. So a will is a way of giving away your personal property. You're also going to be giving away, if you want, to charity. You're going to be picking people to carry out your wishes. They're called the executor. Okay, you're going to do that in your will. And there are many things that a will can do. Okay, and you're also going to be giving away in your will anything with your sole name on it. So for example, if your house is in your name only and you die and there's nobody else on the deed, you're going to have to say in your will who that house goes to. Okay, so we talk about all this stuff when you come into my office, and there's a lot of discussion about your will. And then there's also your power of attorney, which is during your life, you'll have a power of attorney for your finances and for your health. But on this slide here, many of you probably have not even heard of the Register of Wills and what that person does. So each county has what's called we're on the topic of wills, the Register of Wills. And so after death, like the Register of Wills, there's one in Philadelphia, there's one in Montgomery, there's one in Bucks. Pennsylvania has many counties. Each of those counties has a Register of Wills. So after your death, whatever county you live in, that is where your will is going to go to that particular county. It's going to go through what's called probate. We're talking about that in the county that you live in. So for example, I live in Philadelphia. So my will after death, I've chosen an executor. That executor is going to bring my will to the Register of Wills office, which is room 180 in City Hall. Okay, and a new Register of Wills is elected every 4 years. The voters can elect this person, and that's a very important person. Okay, because that is the person that's going to help you to get your assets that you gave away in your will out of your will. Okay, so this slide talks about an estate, and it talks about a decedent. A decedent is a word meaning after you die, you are going to be referred to as the decedent in various documents. But the terms aren't as important as understanding right now that getting a will is really important. Getting planning together is important before your death, because it doesn't take that long, and it will save you a lot in the end. And I don't consider this, when I'm talking about planning, I consider it more of life planning than death planning. So some clients will come to me and say, Maureen, I want to die and have nothing left. I had one today, that a client that said, I want to spend all my money and I'm not giving anything away in my will. And that's what we do. Okay. And some clients say, I want to give to my grandchildren. I want to set aside money in a trust for them. I don't want my daughter's husband to get anything. I just want her to get it. because he's a jerk. Okay, this is the kind of stuff that we can do in the will, we can accomplish. Next slide, please. Okay, so this slide talks about, there's a lot of terms and we touched on them: real property, personal property, probate property. So the first term, real property, what that means is things that you can touch. Okay, think of real. So like your home is a piece of real property. The land, that's all real property. Okay, if you have rental properties, those are all real property. If you have vacation home, those are real property. So those properties, okay, can be given away under your will or in a trust or in an LLC if you have that. But real property means that that property will have a deed, okay, and the deed will have a certain title on it. So everybody also that's on the call should know what their deed says, okay? And if you don't, you should get a copy of your deed, because it's very important to be organized about this stuff, because lack of organization creates a difficulty for your heirs and everybody else, particularly after death, if they can't find certain things. So on your deed, the deed should say if that property is just in your name, or the deed might say that it's for you and your husband as husband and wife, or it might say the deed is for me and my sister and we get 50-50 of the property. I have had many people that don't know what's on their deed, and it's created many different obstacles because they think they own the property 100% and they realize, uh-oh, I only own the property half. I only own half of it. Okay, so it's really important to check that deed, and there's an online service that you can go to and actually pull up your own deed. Personal property we talked about. We talked about the pet that's included in personal property. That you want to make sure that your personal property items, that you give them away properly. Like if you have a certain, like a locket or something very important to you, that may not be monetarily expensive, but it may be sentimental. There's ways of giving that away to make sure that that person gets the item you want them to get. And this right here, personal property, I have so many fights about. I mean, that's really the only word about personal property, that all of the contents of the house were cleaned out, including my mother's prized possession that I wanted. So these things happen all the time. And so it's important to designate who gets what. So if that does happen, it's designated in advance. This person gets this, and you expect it to be there. You expect that personal property to be there, not to be taken out of the home. So as we're talking right now, we're talking about property, and then this slide talks about probate and non-probate. So now we're going to be talking about, before I was talking about what happened before death. Now I'm going to be discussing what happens after death. Next slide. Next slide, please. Thank you. Okay, so we talked about planning. We talked about in your will, what you should do. And we're talking about, now the slide talks about, do I need to probate an estate? So after death, what will happen is, if you have a will, you're going to have to get that, make sure you have an original will, okay? So the original will has to be signed at the bottom by you, and there should be 2 witnesses on it and a notary, okay? Now, you cannot bring a copy to, let's say you die in Philadelphia, so you have to go to room 180 with that will. A copy is not gonna work out, okay? You're going to have the original, and you're going to have to keep the original in a safe place. This is a big problem that many of my clients have encountered, that they can't find the original will. Okay, so you want to make sure that original will, I suggest a safe deposit box, because it's just, and have a key, and give the key away to people that you trust. That's important. In your power of attorney, you can say, this person should get the key to my safe deposit box, but you want to protect your original will. Okay, so you have to have your original will, and that's what you're going to bring over to City Hall. You can make copies, but they're not going to be good enough to go through probate. And in your original will, I just want to point out something. If you don't have time to get an attorney, or you don't feel that you don't need an attorney, you can actually handwrite your will. You can sit down even after this presentation, write out what you want in terms of, I want this to go to this person, I want this to go to this person, I want this person to be in charge, and sign it at the bottom, but it has to be in your own handwriting. It's called a holograph, and keep that in a safe place. It cannot be typed on the computer, cannot be signed on the computer. You have to sign it, and you should date it, but make sure you sign it at the bottom. So that's just something, if you just don't have time, you don't get to just write out something, just some simple instructions. So when we talk about, do you have to probate an estate? What that means is, if you have items that are under your will that you have to give away, okay, so that means anything that's in your own name that doesn't have another name on it. So for example, if you have a joint checking account, a joint checking account means that your name is on it with, let's say, your daughter's name. Okay, so in a joint checking account, you'll have two names on it. So after you die, that joint account is going to go to your daughter. So that account, because it's joint, is not going to be part of probate property. Okay, probate means it's going to have to go through register of wills. So that's not a probate. Your life insurance, if you have a policy, okay, and you put a beneficiary who gets that life insurance policy, that, okay, so you're putting, I want it to go to my daughter or my son as beneficiary. That life insurance policy is not part of your will. It's not probate property, because you're putting somebody on there for it to, for your policy to go to after you die. Okay, now, if you have something that your deed with just your name on it with no one else's, that's considered probate property, because you don't have anyone else whom you've listed as going to take the property. And that's an important thing to understand. So there's certain things. So if you just have a checking account with your name on it with nobody else, that is going to go through your will and who you give it to. If you have a house with no one else, that'll go through your will. If you have IRAs with someone taking it, that doesn't go through your will. Okay. But if you have an IRA that says it goes to my estate, that means it's going to go through your will. Okay. So this is where planning can get involved, whether you want to have to deal with things under your will, your assets, giving them away under your will, or if you want to give them away in other ways, okay, which is called non-probate property. So to summarize, probate property is given away under your will, and they're assets that are in no one else's name but yours. So it has to be given away under your will. Non-probate property are things that have another name on them, like a joint checking account, a will that has a joint tenant on it, an IRA, a 401k, stocks and bonds and things like that do not have anybody on them. Those are going to be under your will. So if you have stocks and bonds, those are going to go through your will. So this is where you want to plan to figure out, okay, what do I want to give away under my will? And what do I want to give away outside of my will as non-probate property? Next slide, please. All right. So we talked a little bit about this, like, do I need a lawyer to probate an estate? So you don't necessarily need a lawyer. It really depends on the person in terms of, like, there's getting a lawyer for the entire process, right? So when we're talking about, like, okay, should I have a lawyer to help me with my planning? Like what I just talked about, like getting everything together, my drafting my will, my power of attorney, my healthcare. Should I have an attorney for that? I mean, it really depends on you as a person. If you have significant assets, complex family situations, I recommend going to an attorney, because if something goes wrong, then it's just going to be very expensive in the end. Now, if you have something very simple that you just want to write out, then you don't necessarily need an attorney. When it comes to probate, okay, if you have a will and it, like, as I said before, if there's complexity, and also there's a lot of terms that you're going to be having to deal with. You know, you're going to be having to deal with like probate, decedent, inheritance tax, different terms that you might not be familiar with. So it really is about your comfort level. You can always see an attorney. Probate process it can be cumbersome. You can start out trying to do this on your own and then say, okay, let me just use an attorney, like consult for an hour. But it is a personal choice. But anything that's complex, you should consider hiring an attorney. And the reason that I say that is because if you're probating an estate, meaning you're going to open up an estate, okay, and so someone dies, you find the will. Do we have a question, Lucy? I'm sorry to interrupt.
Yes, we have a question from a Facebook participant, and the
Sure.
question is, do you want to take this now?
Sure.
Okay. Is it better to get an attorney or an accountant for the probate process? Can an attorney help with accounting for inheritance?
Oh, that's a great question. So in terms of the probate process, the question is about whether should hire an attorney or an accountant. So during probate, you will have to deal with inheritance taxes and tax, like federal, local income tax and things like that. So an accountant, if it's complex tax, like let's say income tax and the person dies and the person has an accountant that's been doing the income tax forever, you should probably use that accountant. But every situation is different. But some attorneys don't do the taxes. I do all the inheritance taxes because the inheritance taxes are really related to all of like what's going on in the probate. But sometimes if they're complex taxes, I will use an accountant for that because that's just not my wheelhouse. So to answer your question, like an attorney is good for all of the deadlines in probate that, you know, the attorney knows probate. An accountant is specific to the tax portions of it. So that's what I would recommend. You know, if you want to try to do this yourself and then hire the accountant for the tax part, you can do that. Or if you want to hire an attorney for like an hour just to get a checklist of what you need to do and then hire the accountant for the tax part, that's including the inheritance tax, that's fine too. I hope I answered your question. All right. So back to the lawyer to probate the estate. So it's the person dies, okay, they have a will. But what we didn't talk about is if the person doesn't have a will. So in answer to this question about do you need a lawyer? So let's say that someone dies and they just don't have a will, okay? But they have they may have a lot of assets. So what that means when someone dies and they don't have a will, maybe they wanted to do it, they didn't get around to it, they got sick. I mean, there's various reasons, or maybe they just don't want to do a will. Okay, so what that now is called is intestate. Okay, so when someone dies intestate, it just means they don't have a will. When someone dies in its testate, it means that they have a will. So if the person did not have a will, what you're going to have to do is figure out who is going to actually be the executor and when of that non-will. Okay, so let me explain. When you have a will, you're going to pick out somebody to do the probate process for you. Okay. And so what that means is in your will, you're going to say my executor is, and you're going to pick out a person, and then you're going to pick out a backup person. Okay. So your executor is going to be in charge. And to that question we had before of like all these details, they're going to bring your original will. They're going to have to find the original will. They're going to have to find the death certificate. They're going to go to City Hall. They're going to either hire an accountant if they need to, hire an attorney. So your executor, back to that question, is going to be in charge of hiring people if they need it. And so your executor, it's great to pick the person out because you know, okay, well, that person is super responsible. My one kid is really responsible, my one kid isn't responsible, but I can explain to them it isn't an insult at all. It's just I want to have this one child be the executor. Maybe you want to have your two children be the executor at the same time. It just gives you the opportunity to coordinate your documents and really get what you want out of it. You want to be able to make sure that this is all accomplished properly. So if you pick the right executor, the executor is going to be timely when they file, and we're going to get into that soon. Okay, all these different documents. But if you don't have a will, you don't have the opportunity to choose an executor. So what is going to happen is you're going to have to go to the court and ask, okay, now, so let's say you have 5 kids. And so one of those kids might be the person that wants to be the executor. But when you don't have a will, that person is called the administrator. So if you have 5 kids, all 5 of those kids, if you don't have a will, could be the administrator. So they're going to all, if only one of them, okay, wants to do it, the other 4 kids are all going to have to sign off. It's called the renunciation, that they don't want to do it. And it really can become a hassle, because sometimes people, some of my clients, they don't want to sign it. Okay, they don't want to sign the renunciation, and it has to be notarized. Sometimes there's fighting about, 2 people want to be the executor or the administrator, and I'm not signing that. Okay, because there's sometimes a confusion about being the administrator just means you have to make sure things are done properly and timely. It doesn't mean you're getting more or anything like that. And there's some confusion about the word renunciation when you receive it. It almost leads you to believe that you're renouncing all of your rights, but you're not. You're just renouncing that you don't want to be the administrator. If you receive a renunciation in the mail, I highly recommend you go to an attorney to understand what you're actually renouncing. Okay. But this is all because if there's no will, there is no one that has been chosen to be the executor. So now there's, okay, who's actually going to be the administrator? And if you don't have 5 kids, if you have like 1 kid and a niece and a nephew, and they all can be the administrator. I mean, you could have 10 people that want to be the administrator. Okay, so this is just one reason to have that laid out in advance. Okay, so the administrator is going to be in charge of everything, and the executor is going to be in charge of making sure that your documents go through probate in a timely manner. And the executor, I want to say this, is a fiduciary. And a fiduciary means that person has to do things properly for the beneficiaries. Okay, they have to do things in a proper manner. And if the executor makes mistakes, okay, and let's say is supposed to pay inheritance tax of a certain amount and they don't pay it properly, they could be on the hook. Okay, so an executor could be sued. I just want everybody to understand, and they get sued in my office, unfortunately, a lot, because if they make mistakes and they mess up and it affects other people's what they're supposed to get or receive, it's a problem. So it's not something to be take on lightly. If you're asked to be an executor and you don't want to be an executor, you can tell them you don't want to do it. Okay, because if things go wrong and you didn't put in a document on time, you messed up a document, I mean, it can be a problem. Okay, so all of these issues demand like some thought in advance. Next slide, Lucy. Okay, so we went over this different types of estates, and it's just outlined on the slides. Testate and intestate. And when you bring your will over, okay, so I just want to go over this. So after your death, you're going to either have a will or not have a will. If you don't have a will, you're going to have to acquire the renunciations. You're going to get a form from room 180. Those renunciations will have to be filled out by the individuals who don't want to be the administrator. They have to be notarized. What you're going to do is you're going to now go over to the Register of Wills. If you're the executor or the administrator, you're going to have to make an appointment with the Register of Wills. I think we could do next slide, Luce. So you're going to have to go over to the Register of Wills and bring with you the will. If there's no will, you're going to bring just the death certificate. Okay, so you're going to bring will or no will and the death certificate. The death certificate cannot be a copy. It has to be the original death certificate. Typically at the funeral home, you get copies. I always suggest that you get more copies than you need. You can also get, if you're having problems getting it from the funeral home, vital statistics. There's a form to get that. I think it's on 8th and Race, I think. So, but if you get it from vital statistics, you're going to have to, go over there. It can be time consuming because it's usually very busy over at vital statistics. So get your death certificate from the funeral home, your ID. It has to be some kind of government ID. You cannot use a passport. Okay. And one tip I just want to tell people, if you don't have an ID, don't stress about it. There is a room over at City Hall where they will make you an ID. Okay. They'll make you one if you have something with your address on it. So you can ask them. If you don't have an ID, you can go over at City Hall. I think it's just across the way. They can make you an ID there. Okay. And if anyone has any questions, they can call me. Okay. So, and you have to be able to pay what's going to be a probate fee. So you're going to have to pay it with a credit card. You can't use a personal check. They won't do that. You can't use Venmo. You can't use PayPal. Okay. Or Apple Pay. Those are not going to be acceptable forms of payment. I actually wish they were, because I just use them all the time, by the way. So I wish the registrar's offices would change that. But as far as that's concerned, so what you're going to do when you go over there, you're going to make an appointment in advance. You're going to call the registrar's office. You're going to, when you come over to room 180, you're going to sit down with a probate clerk, and they're going to go through everything with you. And they're going to ask you for the original will. They're going to ask you for the death certificate. Then they're going to say to you, how much do you think the assets are worth? I think we can go to the next one. Okay, this is some of the stuff that I was talking about. So they're going to talk to you about the assets, okay, and they're going to ask you that. But before you come in, okay, there are actually forms online for this. And one of the forms that you're going to need is called the probate petition. Okay, and the probate petition, and don't let the term scare you. Really, it's just an administrative term. It's just filling out a form about, okay, I'm the executor, the name, date of birth of the decedent, the social security of the decedent. You're going to fill out on the probate petition. They're going to ask you what you think the real property is worth, what you think the personal property is worth. At this point, you do not have to put an exact number. Okay, so do not think on the probate petition, it's 2 pages, that you have to put, oh my God, I have to make sure that real property is $350,000 on Zillow. Later, you're going to put in what the correct values are. Okay, you may not know what the property is worth. Okay, there are county assessments of what a property is worth. There's fair market value. There's different. So just on the probate petition, when they ask you what the decedent's real property is worth, just put an approximation, what you think it is. The same thing when they ask for personal property, you're going to put an approximation and you're going to total it. Then they're going to ask you on the petition, who are the other beneficiaries, meaning who's going to be taking, who did my mom leave her estate to? And you're going to put those names. And you're also going to put on the probate petition whether, they're going to ask you whether there was a will, and you're going to put, if there is a will, you're going to put testate. Okay, if there wasn't a will, you're going to put intestate. And then they're going to tell you, put in your address and phone number, and you're going to also have to put in the Register of Wills address and phone number, because any of the beneficiaries can get a copy of the will if they want. Okay, they can call up that number. You do not have to necessarily provide the copy of the will. They can call up that number. That's something I talk to my clients about, whether we're going to provide that or not. Some executors want to provide it to all the beneficiaries, but that the beneficiaries do have the opportunity to call the number at the Register of Wills office and request a copy. This is an important point. When you create a will, it's a public document, meaning once you bring it over to City Hall and you file it, anybody can ask for, request it. Okay, so if you start writing in the will, my jerk, this one or that one. Things that you write in there are memorialized forever. Okay, so we want to be extra judicious about how that will is written and drafted, because anyone will go in there and they'll look at it, and it really is supposed to be a professional type of document. Okay, it's not something where you're going to go off and start saying my scoundrel this did that, and I've had people that have wanted to put a lot of different types of information that really shouldn't be in the will. Okay, so keep that in mind that it's a public document. A trust is not a public document. Okay, so that's private. So many of my clients would prefer a trust. They want to be private. And there are different types of trusts. It's for another talk about the different types of trusts. But one thing I can say is that minors, okay, cannot. So if you leave money to a minor outright in your will, the minor cannot get that money until they become the age of majority. Okay, so you want to be careful with that. If you leave to your grandchild, even if you leave $100, you can't give it to the grandchild through the will. It has to go to their parents. So you want to put specific provisions in there for minors. A lot of my clients want minors to have it go to like an UGMA account, transfer to minor account, or some kind of a trust if you want to leave for your grandchild. But it's important to note that money cannot be left to minors. The same thing with a life insurance policy. If you have one, you cannot, if you leave it to a minor, okay, if you say your beneficiary is your grandchild and they're under 18, they cannot access that money. Okay, so that's something to coordinate about minors, because many of my clients, I mean, they love their grandchildren. I mean, there's a minor that they want to leave money to. So it's important to note that. Talking about probate steps and things like that, and picking, I just want to make this point very clear. It's important to pick the proper individual to be your executor, somebody you trust. Okay, so this is where in my business, if an improper person is chosen, there are going to be many problems. Okay, so this is like one of the most important things you can do is, okay, who's going to be my executor under my will? Who is going to be if I choose a power of attorney, who's going to make decisions about my bank accounts if I'm incapacitated? You want to make sure that person is a trustworthy person. And so that's something you really, when we talk about seeing an attorney, this is something that should be discussed with your attorney, because the wrong person and money in the wrong hands, and it can be family members, unfortunately, it happens. It's really important. So if one thing to take away, think about who you want to be your power of attorney. It doesn't necessarily have to be your children. It doesn't have to be your spouse. You can also, as your executor or power of attorney, they can be a friend if you have a good friend that you trust. It can be a professional that you trust. Okay, it doesn't necessarily, and people should not be insulted that they're not chosen, because these positions, okay, they can require many hours of work. Okay, so you can be an executor and it can be hours. Okay, it can be like a job. So the person who is your executor has to fulfill a lot of obligations, and they have to do things in a timely manner. So not everybody should be an executor. Okay, that is very important. And remember, if you do not have a will, the court's going to decide who's going to be the administrator. And what happens a lot of time is, okay, I have an administrator now, and that administrator is making mistakes, and it's not the person I want, and it creates a lot of fighting. And that's really, you're not going to be here. Many of my clients will say, I don't care, I'm not going to be here. But the thing is, it's just a problem for all of your family members if they're fighting. Whether you're here or not, it's just not great for everybody to be fighting. So that's just something to be thinking about. If you want to avoid fighting after your death, you don't care, okay, but picking the right fiduciary is a big concern, definitely of mine too as the attorney. Next slide, please. All right, so now we started talking about when you go into probate, an estate. And so this is the documents, death certificate, you're gonna need a credit card, or I think you could do a money order, I think too. You're going to need the will, or if you don't have a will, you're gonna need a government ID. Then you're gonna need the probate petition. That all of these forms are online. Okay, the probate petition, I think you go to the Register of Wills site, whatever county you're in. If you're in Philadelphia, which we're talking about, just go to Register of Wills Philadelphia, and there's a link to forms, and the probate petition should come up in forms. Okay, you're gonna hit that, and you can fill it out, either print it and write, or fill it out on your computer. Okay, so either one of the, if you don't feel like doing it on the computer, you can do it just handwrite. Estate information sheet is just to say who the executor is. That is also one of the forms. You're going to fill this out as well. Okay, so that's just something also for tax purposes, that if there's an executor or a co-executor, that form is going to ask that. Many of these forms are going to ask, just like anything else, they're going to ask, like medical forms, you to repeat information over and over again. So you're going to have to know like what the decedent's social security number, the date of birth, the address, things like that. So just be prepared to have these forms ready. So this is another one of the forms that you're going to have. You're going to have the estate information sheet, the petition, death certificate, ID check. And so you're going to sit down with the clerk, and the clerk is going to ask you, what do you think the estate value is? And you're going to say X, okay? And so if you say like 300,000, then there's going to be a probate fee based on what the estate is worth. Okay, so, and they're not, some states are different and they're higher than other states. So Pennsylvania is not so high, but still, it could be, $500, $600. That's what you're going to have to pay for the check. Okay, you're going to have to check, the money order or the credit card. So you're going to pay the probate fee. And after you pay the probate fee, what's going to happen is the Register of Wills is going to send you, it's either letters of testamentary or letters of administration in the mail. You also should bring, sometimes they have them, but I just want to let you know, an envelope with 2 stamps on the envelope. So everybody make note, because the Register of Wills, the clerk is going to send the letters of administration to you. Or letters testamentary. You're not going to get them that day. Okay. Envelope with 2 stamps, and then addressed with your address on the front. Okay. They'll send you your letters. Once you get those letters, okay, the letters will have a gold seal on them, and they'll say that your name, that you've been appointed. They'll say the date of death. They'll give you a file number. So once you get those particular letters, you can then, like, let's say there's a bank account that's in just, let's say Maureen Farrell, my name, with 100,000. You can take the letters of administration or letters testamentary over to the bank with a death certificate, and you can now act on those accounts. Okay. So you can take the money out, and what you should do now at this point, you don't take the money out and just spend it, or do not put it in your account. Do not put it in a personal account. An estate, you're going to have to set up what's called an estate account for that money. And so that estate account is going to have its own EIN number, and you're going to get that online. Okay. It sounds more complex than it actually is, but so online, you're going to get an EIN number for that estate, because remember, an estate is it's a legal fiction. It's not anything real. Okay. So you're going to get the EIN number online. You're going to have a sheet you're going to print out when you get it online with the estate's EIN number. Okay. And when you get the online EIN number, they're going to ask you like the name, social security. Remember those things I said again, date of death. They're going to ask you if you're the executor. And they're going to ask you just a series of questions that you've been asked before. You're going to get that printout, and you're going to bring that EIN number to the bank with you. And now you're going to take, so let's say you take the money out of the checking account, the 100,000, Maureen Farrell. You're going to deposit the 100,000 into an estate account. Okay. And the reason that you're doing that is because you have to close out this estate. So what I just talked about right now, going to the clerk's office and doing all these things, you actually opened your estate up. You opened it up, meaning you got appointed, you gave them the relevant documents, but you're not gonna be able to close the estate, okay, until you pay the inheritance tax. And that's typically 9 months. You have 9 months to pay it. And if you do not pay the inheritance tax, okay, let's say you inherit a property and you don't pay it, okay, you're going to have problems down the line. Okay, so you really have to pay that inheritance tax. You're going to have interest that's going to accrue. You're not going to be able to sell that property. And like 2 or 3 years later, if you go to sell that property, you didn't pay it, the title company is going to say, I want you to escrow. Let's say the inheritance tax was 5,000. The title company is going to say you're going to have to escrow 20 grand, triple, okay, or whatever, 15 grand until you actually pay that tax. So do yourself a favor with this on your calendar. You're going to have the date of death, and then you're going to have from 9 months put on your calendar from the date of death, I have to pay the inheritance tax. But the important thing to note here is that in Pennsylvania, and all of you are on here, so you get to hear this, is Pennsylvania, within 3 months of the date of death, you can prepay the inheritance tax. And that means you're not going to do the paperwork for it. You're just going to say, okay, if let's say the estate is worth 300,000 and I only have one kid, right? And so my kid inherits everything. And what Pennsylvania says, okay, for kids, they get a 4.5% tax on it. Okay. And so inheritance tax in Pennsylvania is based on your relationship. So if you're a spouse or a partner, there's 0%. But if you're a kid, it's 4.5%. So what you're going to do is to prepay it, you're going to be like, okay, let me calculate this and write a check out within 3 months, date of death, and you're going to bring it to the Register of Wills, the inheritance tax room. I think it's like 182. And you're going to make a copy of just, you have your check. They're going to timestamp it, but you're going to get if you prepay it, you're going to have 5% discount. Okay. So it's worth prepaying it. But I mean, you have to, in order to prepay inheritance tax, you've got to have money to prepay the inheritance tax, right? So like after someone dies, let's say the inheritance tax is 5,000. Do you have 5,000 out of the decedent's money to pay it? I mean, you may not. So this is what a lot of times life insurance, people get life insurance to pay off the mortgage after someone dies, or they get life insurance to pay the funeral bills. Okay. And they get life insurance too to pay these kind of things. So like you can take out a life insurance policy. That life insurance policy should get paid out right away. You'll have that liquidity to pay off inheritance tax, and you'll save yourself 5%. So I'm just giving you this example of the 5%. So let's say that you're the executor, right, of a Pennsylvania estate, and you have no idea about this 5%. And so let's say the estate's $1 million. Okay, I'm just giving a number. I mean, I don't know. And you just say, I didn't know that. I didn't know it's what. I mean, you would be missing 5% of $1 million because you didn't prepay it or you didn't know it. So guess what happens? Beneficiaries, you're taking away their money by not prepaying, right? They're not getting as much money. They could sue you for that you just didn't know, that you're negligent. So, I mean, this is an example of what I was talking about before, that when you're an executor, you have to know these things. So in terms of when we talk about hiring an attorney, people are not going to know, and you're not going to be able to go over to the Register of Wills office and they're not going to tell you this. So this is another thing. They're not going to tell you information. I mean, they're very busy. So you can go over there and it can be very crowded. So it may be good just to get an attorney, just to say, what are some things as the executor should get the attorney of, I need to know. Okay. So that is one example of something you definitely need to know. Next slide, please. All right. So petition for grant of letters. That's what I talked about before. And this is an example of it. It's really a good slide. It just shows what I was talking about. And I don't know if you can zone into that second one, that second sheet. That starts talking about what the different real estate, personal property. On that second sheet on the left side, you're not going to fill that stuff in. They're going to fill that in for you, meaning the clerk is going to fill that in. But if you have any questions, this is where you can, get an attorney. And when we talk about getting an attorney, you can say to the attorney, I just want to pay for an hour of your time, and I just want you to tell me how to do this. Okay. And that's what you should do. I just want you to help me fill out the petition. I may want you to come to the Register of Wills to help with this. And if you have like complexity, just one thing, let's say you have a stepson or stepdaughter. I mean, there are a ton of blended families now, and you don't have a will. Okay. In Pennsylvania, if you have a stepson that, not related at all by blood, they don't get anything. So if you don't draft a will and write, and your stepson, I have a client this happened to actually, if you don't write, my stepson gets X or my stepson, and you don't have a will, they're not getting it. Okay, because if you don't have a will, the state will determine where your property and your assets go. If you have a will, you determine. But if you don't, the state is going to say, okay, the first thing is the assets go to, if you have a spouse, they go to the spouse. But then if your parents are alive, some of your assets could be going to your parents who could be older, and it's like, and then if they die, they're going to have tax consequences. So I mean, it's really important. You're going to be deciding where they go if you have a will, but if you don't, the state is going to decide exactly where your assets go, and it may not be what you want. So this is really all about what you want. Next slide.
And Maureen, we got another question. Is that all right? Do you want to take that now?
Yeah, sure.
Okay. Somebody asked, so would you have to pay multiple fees if the value you listed for the properties was not accurate and you have to fix that amount on the estate info sheet?
Oh, these are such good questions tonight. They really are. So what happens is with the value, at first you're going to approximate because you may not know. And then the value, let's say, of real property, to answer this question, like you're going to figure out what the value is. But what I do with my clients is like, there's the county value, right? What the county assesses. And then we use the county times what's called the common level ratio, which can sometimes give a lower value, but you're going to put the correct value in answer to this question on the inheritance tax. So that's really the most important thing. At the end, we're going to say, okay, the value of this property, let's say the real estate, if you sold it, you may want to put the sale price on there, because we can deduct real estate, like certain taxes we can deduct. So what I do is I decide what the value should be. So I'll decide on the inheritance tax, okay, what's the value we should use? Should we use the sale price? Is that the best value? Should we use the county value? A value on Zillow isn't necessarily the value. Okay, so to answer your question, as long as it's corrected on the subsequent documents and on the inheritance tax, and hey, if it's messed up on the inheritance tax, I mean, we can just write a letter and just say, here's supplemental, we fixed it. So yes, you have an opportunity to fix it. But in the beginning, it is acceptable that you don't know. I mean, because the person just dies, you're not necessarily going to know the correct value. Thanks for the question. I hope I answered it. All right, so we went through the letters testamentary. I just want to bring up one thing on here, this slide, which is short certificate. So what happens is a short certificate, when I said you get that letters testamentary or letters of administration, it's like a bigger type of form. A short certificate is just, it doesn't have the gold seal, but it's just like, it's easier that like you go to the bank and you can bring the short certificate with you. So sometimes I'll get a few short certificates. It's just a shorter form of your letters of administration or letters testamentary, and it's acceptable. Like if you go to the bank, they'll say, do you have a short, just so you understand this term, they'll say, do you have a short certificate? So you can request short certificates. I had a client, I think I had 30 of them. we had a lot of, so sometimes maybe request like 10 or 5. So the bank will take it. So, or if you have a brokerage account, you're going to need a short certificate. So these are things that it's a shortened version, but it gives you the power. Just remember, you don't have any power. Like until you become executor or administrator. So if you go to the bank and you want to take out the decedent's 50,000 after he died or she died, you're not going to be able to. They're only going to let you do that once you become administrator or executor. You have no power whatsoever. Okay, so once you get that power, that's when you can start doing things at the bank. You want to change, you want to Social Security, you want to stop that. You want to forward the mail. You want to make sure this is mail sometimes gets lost to your address. Okay. The post office at 30th Street or wherever I try is somewhat it's not up to speed. So sometimes I will just forward the mail to my address. That and also I want to mention this one thing. When someone dies and there is a vacant property, it is a serious issue. Okay. And squatters are going to go into these properties. And I mean, it happens all the time in my office. It's just, or a relative might be in the property that will not leave. And if you're the executor, that property, if there are 3 kids and one kid just wants to stay there, it's all the kids. If it was given away to all the kids, it's all of their property. So, and some properties can get destroyed. So you wanna make sure you secure that property. Okay. And if someone is living in there, and if there is a squatter, you are going to have to eject the squatter. Okay. And that's something that I do a lot. Unfortunately, I have to eject squatters because they find out where vacant properties are. So a vacant property, it's very important if it's vacant for you to go over there if you're the executor and change the locks right away. Okay. And make sure, put up a no trespassing sign. And you also have to, this is an important point. I want to bring up some things that you wouldn't know on this seminar. You have to get homeowners insurance on that property. Now you may be saying to yourself right now, well, I have it. I have homeowners insurance on that property. If you're alive and you have homeowners insurance, you have it, okay, under your name as a living person. Okay, you have what's called an insurable interest. Once you die, you do not have homeowners insurance. Now there are riders that you can get on your policies to make sure the insurance carries over after 6 months of death. So now what happens, let's say you have a vacant property, you have to change that lock, you have to secure that property, all the windows, you have to make sure the property taxes are paid, you have to make sure, you're talking about changing utilities, you have to do all that. So you have to get homeowners insurance under the estate for that property. Okay, it's very important. I actually had a client, there was an electrical fire. Okay, there was homeowners insurance, but if you don't have that homeowners insurance in the name of the estate, and the insurance company will try sometimes to say, you have it. No, you don't. You have to get an underwriter to write a new policy in the estate. Next slide, please.
Also, just to give you an idea of time, we're at 7 now. So I don't know
Oh
if you
my God,
want
we're at 7. Let me just wrap up real quick.
Okay.
Thanks so much, Lucy. I think we started a little late. All right, so this is all like some basic stuff that we kind of were talking about. File tax returns. You're going to file the inheritance tax return within 9 months. You're going to have to pay off credit card debts and file an inheritance tax return, paying off any kind of debts. You're going to have to do that. And then once you pay the inheritance tax and Harrisburg sends you what's called an appraisement, then you can pay out the beneficiaries. But you have to pay out creditors and do things like that, and pay taxes before you pay out any money. Next one. Notice form. So this is when we're going in an estate. You're going to have to, once you open up an estate, I go through a checklist with beneficiaries. With executors. After 3 months, you want to send what's called the notice form. These are online. Okay. And the notice form will say that you're beneficiary under the will. It's just a form that makes sure that beneficiaries are aware that they may be getting something under the will. And that also has to go to the court. So remember what I said, executor has to do a lot of administrative tasks, but they have to definitely send out a notice form to beneficiaries. Next slide. And this is an example of the notice form that's online. And as I mentioned, there's a 3 month. So within the date of death, you need to send this out to each beneficiary after 3 months. Okay, 3 months is your deadline, so just put that in your calendar. All right. We sort of touched on all this about opening an estate account. And then within 6 months, we talked about that question. You're going to file an inventory, and that's sort of to correct some of those values you may have like misvalued. That'll be on what's called the inventory. You're just going to list the estate assets, and you're going to send that to the court as well. With these forms, inventory and the notice form, you're going to make 2 copies when you bring it over to the Register of Wills. Next slide. And that's an example of the inventory form. And the inventory form within 6 months of date of death. Just make sure you put all these things on your calendar, and you're going to sign that as the executor when you're the executor or the administrator. And usually I attach some sheets to this, but on the inventory form, you're just going to list real estate is this, personal property is this amount. And this is where you have an opportunity to correct anything that you listed incorrectly before. So file taxes within 9 months, and you're going to get, it's called Form 1500. This is where the accountant question, I would recommend having an attorney file the tax. There is a lot of different complexity about what should be taxed, what should be a deduction. So you want to definitely, if it's simple, that's one thing, but if there are a lot of different deductions that can be taken, you may not know about, and they're different taxes in terms of like, okay, inheritance tax is this. Do I have an estate income tax to pay? Do I have a federal income tax to pay? I mean, this is the part where I would say hire an attorney or an accountant to help you. And so paying off all debts, you're going to pay off all the funeral bills. There's an order to debts that are going to be paid off. And so this is the order of the debts that are going to be paid off. You have 1 year from what's called an advertisement. Okay, you're going to advertise in the local paper that your loved one has died. And so once you advertise in the local paper, you have 1 year from that advertisement to pay off all the debts. Okay, so after all this, you know, you've paid off all the debts, you've paid off creditors, you file the taxes, you get your appraisement back from the tax person, that from Harrisburg that says I don't owe anything. This is when you distribute the assets. Okay, and so you want to distribute them to the beneficiaries. What I always do is I always have some kind of release and sign off that they got their money, and you know, you're going to write out the checks, and you're going to distribute the asset though from that estate account. Okay, so just remember this, everything goes through the estate account, and then eventually you're going to close the estate account. Next slide. Transfer real property. So, I mean, this slide is something that you're going to do in terms of like the deed. Like if you're selling it, it's going to be sold to somebody, so it will be transferred through a title company. If it's transferred through, okay, these people want to, like the heirs want to stay in the property or own the property. So this is another thing where I think you should talk to an attorney about the property, okay, about selling it. Is it a good time to sell, or should we just, is someone going to live in the property? Does somebody want to buy somebody out? Okay, what's going to happen to that property? Property is a big deal, and dealing with property taxes, who's going to pay that? So this part I would recommend an attorney for that. All right, so we're down to the end. And so closing the estate, you've done all this work. The executor has done all this work. And so after you've done these things, you've given notice after 3 months, you filled out the inventory form after 6 months, you filed the taxes within 9 months, and now you've distributed the assets and you've sent every beneficiary, okay, you got your asset, you release me. Now you can close everything, and you can close it. And what you're going to send in is a status form to the Register of Wills that you've closed everything. You have 2 years to do that. And once you've done that within your 2 years, then you're basically done. But I want to wrap up with, like, there's a lot of work here. I mean, even in just me talking, I was talking about a lot of different things. I wanted you to hear that about things you may not have known. Okay, all of these forms can be found online at the Register. Plug in the Register of Wills and look under forms. But it really is up to you how you want to go about this. But it's good now that you're on here, and I appreciate everybody who's on here because it just gives you something to think about, and now you have more knowledge about it. I'm not sure if there's another slide, Lucy, but if there's any questions. And I just want to give my contact information. Maybe we can send it. I don't know how that works, Lucy,
Yeah, I'll send out all these slides and the recording will be up, so I can also include your contact information.
Yeah, I just want to leave with my phone number. It's my direct line is 215-337-2012. I told Lucy I just changed offices, so that's why I have this background. I'm in process right now. And that's my direct number, and I'm happy to answer some questions for you if you just call me and let me know you were on this presentation. And my email is Maureen, Maureen at Maureen, and my last name Farrell, F as in Frank, ARRELL.com, Maureen at MaureenFarrell.com. And my name's Maureen Farrell, so you could probably find me online. But I appreciate everybody on, and especially the Free Library and Modern Courts as well. You guys do such a terrific job with particularly getting out the vote. And now I'm getting myself a library card after all these years that I didn't realize I could get Libby and Kindle. So it's great. So thank you guys.
Thank you so much, Maureen. This is fabulous and really, really helpful. We really appreciate your time.
Oh, thank you. Are there any final questions? I just want to make sure.
I don't see any right now. People must have gotten them in earlier.
Okay, good. All right. Well, thank you guys so much. I appreciate it.
Thank you. Have a great rest of your
I think it
night.
went well. Thanks. Have a great night, guys. Bye.